to the speakers now. Hello to those of you who are here and people in Radio Land. I don't know. Where is the camera by which they're seeing? Okay. Anyway, so this is a session about neuroscience and the law. I think more generally, you could think of it as neuroethics. My name is Josh Sames. I'm a very reductionist molecular type neurobiologist. I'm quite interested in this for several reasons, and I hope you will be too. The first is it's just really interesting. As neurobiology gets more powerful, it's impinging on everything, philosophy and art, politics, business, and so forth. And that brings up a whole range of ethical, legal issues that are fascinating. Number two, for those very same reasons, it's quite important. As I said, this is not my area, but I've served on some committees and gotten to see what the implications are of sort of increasingly sophisticated neurobiological knowledge. The third reason that it's good to have you here is that although there's many neuroethics groups at Harvard, with the recruitment of Francis and Gabe, you'll be hearing from, it seems that things are sort of coming together on what's been an effort maybe focused in large part at the medical school and the law school, and other schools, including GSAS and sciences. And then I guess last, I don't really know whether we're going to go into it, but there's sort of a specific opportunity because Francis and Gabe are trying to sort of start a new center, which if it's funded, and we all hope it is, will provide some new opportunities for people to get involved across the campus. So that's why I'm here and why I'm glad you're all here. So let me just introduce, I'm going to introduce Gabe and Francis together, even though they are not going to speak in unison.
Josh, can you speak up? People are having trouble.
Oh, okay. You can hear me here, right?
Yeah.
Yeah. I'm not even sure that they're real people. At any rate, so Gabe is an assistant professor of psychiatry and global health and social medicine. He's a PhD from New York University, where he did his thesis work with a number of people, including Joe Ledoux, who's a very famous name to us neurobiologists. He then got his law degree at University of Pennsylvania and joined the faculty here a few years ago. Francis is also a PhD and a lawyer. He got both degrees at Harvard, the JD obviously from the law school, a PhD from the Kennedy School. He then moved to Minnesota and has been oscillating back and forth between Minnesota and Harvard in ways that I just really don't understand. But last year he kind of landed more or less permanently at Harvard, where he is sort of taking on the directorship of a lot of the neuroethics programs here. So they're both going to talk a little bit about what they do, I think a little bit about what the prospects are for raising the profile of neuroethics and neurolaw here on campus. And I think we're going to start with Gabe. Go to
Yes, thank you so much. Thank you for the introduction. And I wish I was there. I tested positive for COVID on Monday, so I'm pretty sure you wouldn't want me there. So, I'm here. All right, so let me go ahead and share screen. And while I do that, I'll start. Okay. All right, let me know. Let me know when you can see the screen. Can you see the screen that you're supposed to be seeing?
Yes.
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 Okay, great. Okay, wonderful. All right, so I'm gonna talk about some emerging issues in neuroscience and the law, and these are all issues that were in my research team that we're covering. We work very closely with neuroscientists. You'll see that part of the work focuses on neural devices, particularly deep brain stimulation and adaptive deep brain stimulation. And then a lot of the other work focuses on psychiatric and neurological genetics. But you'll see that there's interesting, fascinating, I think, intersections in neuroscience and the law across many different contexts. I'll talk about the research context, just give you some examples. I'll talk about some examples that we're actually working on. Talk about the kind of court proceedings, court context, which is something that Francis definitely knows more about. And then I'll talk a little bit about an emerging clinical issue that I think is really interesting, and this is all spurred by emerging technologies and which are based on the knowledge that all of you are creating. And so I hope that in some way, if you ever find yourself asking yourself some question that you think may have some social, legal, or ethical implications, feel free to reach out, and we're always happy to explore those issues. All right, so are we entering a brain implant era? I'll start with that. So I guess maybe, and for some people, so there's definitely a lot of investment going into it. In the US, the Brain Initiative and NIH, DARPA are investing a great deal in brain implants. Obviously, Neuralink, people know about, but there's a lot of other companies like Abbott, Medtronic, and Boston Scientific that are focusing more on the kind of clinical applications of some of these brain implants. And generally, the way that these brain implants are being used, again, like as an example, deep brain stimulation, which is pretty commonly used for Parkinson's, is for severe and treatment-resistant brain-related conditions. That's usually, it has to be something that the person, and I'll give you an example, but it has to be something that the person has tried, many different kinds. It has to meet a very, very strict inclusion-exclusion criteria. So it must be something pretty severe and treatment-resistant and proven to be treatment-resistant. But of course, there's people that are interested in not only keeping it to the clinical context, but also expanding the uses, sort of the brain of things, you could say, connecting the brain to all of the different devices that we use. Listening to music, changing, your music, etc. So there's definitely a lot of interest in expanding that, and you could think that it, from a market standpoint, it makes sense. And I'm not making an ethical, judgment here, but you could argue that it makes sense from a market standpoint to go for everyday uses, because then you go from patient populations who are suffering from severe treatment-resistant conditions to everyone potentially who can possibly access this and would have an interest in accessing this brain implants. Now, this is just to give you an example. Like, this is what the brain implants, like you can see on the top, Medtronic's look like. The battery that you can see here, it's about a 2 by 2 inches. It goes in the chest. And then you have the leads and your contacts that would go into the brain, and surgery much more complicated than the kind of surgeries that I was doing in rats back at NYU. And in this case, this is a patient who received deep brain stimulation, and the placement of the leads is in the ventral striatum with the goal of managing symptoms of obsessive compulsive disorder. And that's one of those areas in which we're seeing growth and some good evidence that it could help a number of people with treatment-resistant obsessive compulsive disorder. Now, with Neuralink, and I use Neuralink as an example because it's not just Neuralink, it's really a lot of different groups that are trying to, they're just being more vocal and obviously maybe have more money, but there's a number of different groups that are trying to figure out ways to make these leads more flexible at contacts, be able to get to different areas of the brain and record and stimulate from different areas of the brain. Neuralink has also talked about potentially developing a surgical robot that would, also, improve on the ability, the capacity to be able to implant these threads or these more flexible leads into different parts of the brain. That way you can access more and again, be able to modify and perhaps regulate different kinds of mental states, emotions. It's also used for different movement disorders, so motor outputs, etc. All right, so as I was just saying, so there's the deep brain stimulation, the conventional deep brain stimulation, and in this case, like what the system basically does is that the surgeons will implant the device, the leads into the brain region that they learn. Basically, if you stimulate or increase stimulation of that brain region, you get some control over the symptoms. So obviously there's projections to a bunch of different places, but these are regions that seem to work for different kinds of symptoms. So at this point, basically the conventional deep brain stimulation that I'm talking about, you turn on the system, you start stimulating, and eventually the battery will deplete, and you may change the parameters of stimulation, but it's not responding to any sort of brain activity that's going on in the patient's brain. So this is not really an interactive system. Now, what a number of researchers that we're collaborating with are trying to develop, not only are they working on deep brain stimulation, the conventional, but also adaptive deep brain stimulation. And the idea is that you can, now record neural activity, identify a biomarker associated with the onset of the symptoms, and either have a baseline level stimulation that helps manage those symptoms, and then you increase the stimulation to help kind of regain control if the patient is experiencing symptoms, or you just have the system turned off and it turns on just when the patient is experiencing, or you identify, the system identifies that biomarker associated with the onset of those symptoms. So you might imagine that this now it starts to get, I think, very interesting, because now we're talking about developing biomarkers for something like depression, so something like sadness, or the anxiety experience with obsessive compulsive disorder, or the urge experience to seek certain things in addiction. And then you have a number of other conditions for which this is also being used for, and which you might. It's also it's also used for seizure as well, and you might think, or we'll have some discussion about that, but you might be more worried about the sadness, the some of the ones that may say something about our emotions, but I think there are interesting things to consider from a legal standpoint about all of these, and from an ethical standpoint. All right, so the first issue that I want to talk about is something that I've been honestly worried about, and I'm looking for answers for a bit, and that is post-trial access for patients who participate in these trials. So I'll give you an example, and this is not by any means the only example, and I'm not looking to sort of put this group on the spot, because they've actually, many of them have done a lot to try to be able to give their patients access to the device and maintenance of the device. They've actually been great about it. But in the largest deep brain stimulation trial for depression, the patients, many of them needed to have had, so basically the eligibility criteria, let me start there. My COVID brain is playing tricks on me. Let me start with the eligibility criteria. So you needed at least 4 trials, and this is so you can get a chance to see that not everyone is able to access these devices. So you need at least 4 adequate trials of antidepressants. You needed psychotherapy and something that's considered adequate psychotherapy. And in this case, this is not necessarily an eligibility criteria, but in this case, 80% of the participants had undergone electroconvulsive therapy for treatment-resistant depression, which is, something that in some cases can help patients with treatment-resistant depression. Now, here's my concern, and so about 30% of these patients had suicide attempts. They had been experiencing these symptoms for at least 12 years, or on average for 12 years. And when the trial started, it didn't, at least during the first 6 months, it wasn't working. They weren't seeing the differences that they were expecting to see, to say that they had a group of people receiving the stimulation and a group of people that had gotten the device but were not receiving the stimulation, and we're going to start receiving it after the 6 months. So they were not seeing the differences that they were expecting between the groups, but they were able, the researchers sort of lobbied with the sponsors to try to be able to do a follow-up study, and they followed these patients, all of them by then, or the ones who decided to stay in the follow-up study, all of them receiving the stimulation. And by the end of the about 36 months where they did the follow-up study, they actually found that about almost 80% of the patients had at least a 40% decrease in the symptoms of depression. So these are people that had not, responded to anything before, finally find something. Now the trial is over. So what happens with these individuals? Is there a legal obligation to provide post-trial access and maintenance to these devices? And the answer is no, not in the US. The common rule, basically IRBs have not been, kind of saying much about this. It's difficult also for many of the IRBs to be on top of every single, potential issue that may arise. But most of the research that's going on does not have any, basically what it says, the consent forms, what they'll say is that at the end of the trial, the clinicians will reach out to your insurance provider and see if there's any chance that the insurance provider may cover the device and the maintenance of the device. Now, these are experimental indications for these devices. So, many of the basically the insurance providers do not have a legal obligation or a contractual obligation generally to provide coverage for these devices. And it can be pretty expensive. I won't get into the cost, but it can be pretty expensive. There's been a number of mostly in the declarations and reports suggesting that there should be post-trial access, mostly for drugs, but it's something that we're still struggling with, and even in the post-trial, in the development of drugs, is still a problem, and it's something that we're seeing, and one of the reasons why I worry about this, particularly with the patients who are receiving these devices, is that these are patients, again, that have treatment-resistant conditions. Nothing else has worked for these individuals. We're not talking about, obviously for these companies, it may be really expensive, and that's part of the conversation that we need to have about whether this should be covered or not, and in which circumstances. But it's one of those places where you can see the intersection of the law and neuroscience and the well-being of these participants. And I've heard from many of them, saying that it would be extremely difficult, if not impossible, for some of them to go on if they didn't have access to the maintenance of these devices. So I think it's something that we need to take a look at very closely, and hopefully, figure out a way. And I know that, many of the sponsors, many of the device manufacturers worry about this as well, the researchers for sure. But we need to start making progress, and it's one of those intersections that we've been examining. All right. Now, moving a little bit to more of my good friend Francis' court, like basketball court, but like also the legal court. So this is from 2017 Wired article. Your own pacemaker can now testify against you in court. And so this was a case of an individual, Ross Compton, that alleged that he awoke to find his home on fire, but basically he had time to pack his belongings in multiple bags, his laptop, and the pacemaker charging. So when police the law enforcement was investigating the case, they also found that there were different places in the house where the fire seemed to have potentially begun. So they thought, maybe this was something that this guy did, So, but the guy said that he was asleep and he just woke up. So they knew that, or found out that the individual had a cardiac pacemaker. And they thought, well, if you were asleep, then we would expect a certain level of, we all have our Fitbits and our different, devices. You would expect, usually a lower number of beats per minute, etc. So they were actually able to get the warrant for that pacemaker data, and the cardiac data from the pacemaker suggested that he was not asleep when the fire started. So he was charged with arson and insurance fraud. So this is your heart's device speaking against you or testifying against you in a sense. Now, what about your brain? So we've heard already from a number of different researchers, and I'll give you one example. So there was a researcher that was approached about providing data from a neural device for that was being used, sort of these deep brain stimulation devices for seizure, because an individual who got in a confrontation with police officers became aggressive, and part of the defense was that he might have been having a seizure during that moment. And so they basically that hasn't been looked at in court yet, but we do have in the US at least the precedent that your pacemaker can now testify against you in court. And of course the Fifth Amendment that we all hear so much about, says no person shall be compelled in any criminal case to be a witness against himself. And so in this case, we already seen some courts saying, hey, if it's a cardiac pacemaker, it's okay. If it's relevant evidence, we can allow that. But we still haven't answered this question, and that doesn't mean that was correctly decided. But we still haven't answered or seen examined in the courts the question of whether an individual who gets a deep brain stimulation device, let's say for obsessive compulsive disorder or for some other condition, should have to provide data from their brain in order to try to figure out if their version of events seems to be aligned with their deep brain simulation data. So in that sense, we'll need to figure out if do you think, and I'll ask you this question, or we can examine this. Do you think that there's a meaningful difference between your cardiac pacemaker data and another organ just above it, and your brain? Is this going too far now when we're talking about obtaining data from a deep brain stimulation device? So that's another of the issues that I wanted to bring up. And now going back to the internet, Internet of Things or the brain of things, this is from Neuralink's website. So one of their goals is to try to connect your brain to you name it, languages, artificial. I heard this artificial intelligence devices that would allow you to access information, etc., and also to be able to text, because well, I'm not gonna. Well, maybe our for some people they could benefit from being able to text from using their brain activity. But for other people, from a medical standpoint, but for other people, it may just be just kind of, some people may call it an enhancement. And we have to start thinking about what kind of uses of this type of technology, if we get there, do we think is correct? Do we think people should just decide on their own what they want to do, what kind of risks they want to take, and what kind of data? Obviously, once you are able to do some of these things, you're able to access a lot of information. So there would be a lot of privacy issues also to consider in terms of how the data is managed by the companies, etc. And then I'll end with this. This is a little bit different, but it's an area that I find really interesting. We have an R01 that started last year on polygenic embryo screening. And so right now, for people who undergo in vitro fertilization, you'll generate a number of different embryos, and usually the decision about which embryo to select comes down to morphology of the embryo and a number of other. It may include also some genetic testing, but with the growth of genome-wide association studies, now we're also seeing companies offering to look at things like risk for schizophrenia. And I'll talk about this just one second. Obviously, my daughter just came in. Mi amor, estoy dando una charla, discúlpame. Mi amor, que estoy dando una charla. She knows I have COVID, and now she's like, "Oh, you touched me." Okay, so with this genome-wide association studies, we're seeing a huge growth of the sample sizes, particularly for psychiatric disorders. So that's now one of the things that people are trying to figure out is, and I know that many of you work may work on molecular mechanisms of some of these psychiatric conditions or neurological conditions. And for example, with psychiatric disorders, a person in the 99th percentile with the current estimates, a person in the 99th percentile PRS for depression would have about an absolute risk of 30% for developing depression in their lifetime. A person with the 99th percentile for polygenic risk score for schizophrenia would have about a 6 to 8% absolute risk. One big thing is, obviously if I tell people, or if the companies only present the 99th percentile or the relative risk, it sounds a lot more than when you talk about the absolute risk. But usually they use the relative risk, which is one of those communication issues that we're seeing. And there's a number of companies that are offering this type of screening for embryos. And they offer a report card for each of those embryos. This is one example on an article. For the different conditions, type 1 diabetes, type 2 diabetes, that they can generate the scores for. And then the idea, and now they're offering schizophrenia, and I wouldn't be surprised if they start offering more and more psychiatric conditions. In any case, as a potential parent, you could also request the data, the raw data, and go ahead and upload that raw data and generate the scores for educational attainment, generate scores for any other characteristics for which we have enough genome-wide association data for. And they'll also rank the embryos. We can discuss that, and and so here's the legal intersection, and I'll end with this. In 1992, there was the Congress passed the Fertility Clinic Success Rate and Certification Act. And so what this did, the main goal of this was to make sure that fertility clinics were reporting the success rates in a more consistent way, because obviously you might imagine how you can play with the denominators in all sorts of ways when you're reporting something like success rates. So that was the point of that legislation. But it also added that the secretary, in this case of HHS, which the FDA is under, cannot establish any regulation which has the effect of exercising supervision or control over the practice of medicine. In this case, practice of medicine being defined as artificial reproductive technologies. So this took away the FDA, from a legal standpoint. There's still, some debate as to whether this could be possible or not. But you could argue that it takes away the FDA in terms of supervising the kind of tests that can be done in these embryos. And it leaves us with the Federal Trade Commission, which could look at the ads and, they must be truthful, not misleading, etc. But they can't really look at they can't really limit, what you screen for, etc. Many other countries in Europe do have, the UK, have certain regulations as to what kind of conditions the people are able to examine, but that's not the case in the US. And so one of the things that we've been looking at is so it's not all about trying to get a law in the books. There are other ways in which you can use the law and policy. So we're trying to work with professional organizations to try to identify best practices and hopefully improve the communication of all of this information, and how the science that has been developed by many of you can be used in a way that helps people make decisions that are consistent with their values, which is something that I kind of I'm a big believer in. It's very difficult when we get into, particularly in the reproductive context, where we've done so much to try to move away from the horrors of eugenics by, in many ways, protecting the individual decision making. That I think it's really important that we start setting at least some standards as to how we communicate some of this information, so people can make those decisions according to what they really want, and understanding the choices that they're making. All right, so I'll stop there, and I don't know if we want to. I mean, we can do questions at the end. Absolutely.
Yeah, I think we'll hear from Francis next, and then do
Perfect.
questions for both.
Perfect.
So Francis now.
So I need to plug this guy in, right?
Yeah, you can just go.
Okay.
Good.
Yeah, I need to share this with the Zoom folks, right?
Just speak as loudly as
Okay.
possible. The one mic, I guess, benefits from that.
All right. Zoom folks, you see the slides? All right, yell at us if not. Obviously, you see the slides. So, okay, well, let's get going. I'm Francis Shen. I want to first thank Farzad and Josh and the Harvard Brain Science Initiative and Center for Brain Science for helping us put this together. It's never easy to do any event, especially a hybrid event. So thank you for that. I have no disclosures to offer, but I want to acknowledge anyone who's been silly enough, smart enough, to fund the work I do. And I always give myself a challenge when I present on law and neuroscience. And here's what the challenge is. I say to myself, limit just in the last week, maybe 2 weeks, is there a brand new law and neuroscience instance in the world? And I have never, the world has never failed to give me one. Here's one from yesterday. This is the news story broke yesterday. The case goes on and on. So this is a case where there's someone on death row. And one of the legal options you have on death row is to say to the court, the individual you want to put to death is no longer competent. And this is not new. This type of argument's been going on for a long time. What is new is the advent of brain science into these considerations. And so right now, there is someone who is fighting for his life, and his attorneys are referencing brain science. They argue that they show that there's a 15 millimeter lesion in his brain that's growing, and they argue that that plus other behavioral evidence leads to the legal conclusion. So the medical and scientific evidence leads to the legal conclusion that he doesn't have competency. What does the other side say? You're going to see this theme in my talk and in our field. They say courts have consistently found here, Mr. Cole's brain lesion does not interfere with his understanding of his case. We'll say, okay, you have your brain information, your medical evaluations. We have legal standards. And that in a nutshell is law and neuroscience. How do you take the world of medicine and neuroscience and apply it to law, where we have our own words, our own categories, legally, not scientifically defined. So in this talk, I want to give you the punchline first, and it's similar actually to that case that I found. It was nice. There are a whole bunch more instances in neuroscience and courtroom, including being led by many folks on this campus, but there are some real persistent challenges. And two of the big ones are individualization, right? Going from group average scientific data to an individual defendant or plaintiff, and the continued just mystery of complex mind, brain, behavior implications, and sort of the footnote that in law, we take the science you do for disease and health, and then we say maybe it has some applications to law. So with a very, very few exceptions, like I can name the 5 people on my hand, there's not neuroscience work specifically designed to look at legal categories. There's no neuroscience of competency. There's neuroscience of all sorts of mental illnesses and other disorders. So we're always dealing with that challenge. And this leads to one of the conclusions, which is we need better tools, and I'll talk about that too. So I want to talk about the past. The past of neuroscience and law ain't pretty. We should acknowledge that because it influences what we do now and in the future. I'll say a little bit, because I don't have time, about what's happening right now. And again, we're going to keep seeing, again, the courts really want to see what's happening to this individual's brain. Of course, that's the same thing in precision medicine. But it's plays some particular role on the legal side. And then I want to talk about the future with the real emphasis actually on, I see, many faces and some names on Zoom who I think are in the student or fellow or postdoc or early career mold. And so I'm trying to encourage you to maybe get involved and give you some opportunities. As Josh was saying, and as Gabe mentioned, there are some really cool new things happening on campus. So I'm excited about that. All right, so I direct a lab that looks at the intersection of law, ethics, neuroscience, and AI. Our motto is every story is a brain story, which I think is true, but 2 caveats to say right off the bat. Caveat 1, every story is a poorly understood brain story. You know that, but it's really important because the bravado of lawyers, we tend to want to say when we're arguing in court, well, we know this, we know that. And science proves. I love to say, science proves. I've got hard data, I've got hard science proof. No. That's one problem, one caveat. The other is that every story is not just a brain story. Every story is, of course, also a story of environment and family and everything else. But brain's really important. So there are 2 big questions we pursue, and they kind of work in tandem. One is taking the stuff, and I'll talk most about this today, but I'll reference some of the other stuff. What are we learning about the brain? The brain-mind behavior relationship, and can it contribute to a more effective, just legal system? Now, there's an ethics component to this, which is how do you develop new technologies that you need to answer those questions? And then there's an arrow pointing the other way, and Gabe just talked a lot about this, which is, okay, we're not just going to let science run wild. We're not just going to let new neurotechnologies develop without legal regulation. And I thought that polygenic risk score is a great example at the end. And so we also look at how the law and ethics can guide the development of these technologies. So there's a lot of ethics cooked in here. I'll focus on the law, but you'll see the ethics show up. We do empirical work, theoretical work, a lot of education and outreach work. We collaborate a lot, all kinds of research assistants from all sorts of disciplines, and we publish on a lot of different stuff. I'll talk just about a little bit of it. If you get interested, one just kind of resources, lawneuro.org, MacArthur Foundation Research Network on Law and Neuroscience. There's a working bibliography and videos of every event we've ever run there. Okay, so let's talk briefly about the past. And I wish that these next slides we didn't have to talk about. I wish that there were a stronger history, but there's not. Here is one summary from an article that I read, but quoting ethicist Paul Wolpe at Emory has said, quote, "History has shown us the repeated policy failures of a biologically based approach to criminal justice." I think he's right. If we had more time, we could sort of list off the ways that the exuberance of embracing science and bringing in the legal system didn't turn out so well. And I think that means one of the central challenges is, do we learn from all this? Or are we just going to replicate this history? Let me give you just one example. There has been this repeated search for, and I put it in quotes, the violent brain. I mean, this is what documentary, right? It's what's going to get you on Netflix. And a lot of people have written on it. So I'm not going to talk about his book, but our colleague Adrian Rain at UPenn wrote a book in 2013, The Anatomy of Violence, using MRI and PET scans to try and compare normal folks with those who kill. What's the difference? But 40 years before that, there was a book came out of this area. MGH from Harvard, Violence in the Brain, Vernon Mark, Frank Irvin. This was the height of psychosurgery, in the late 1960s. They too thought that they could harness science for the good. Thankfully, that never took off, but it could have. And even 40 years before that, I think for those, I don't know how well you can see this, a commemorative slide, but for the prefrontal lobotomy, wonderful tool that won the Nobel Prize for Dr. Moniz. You probably know that. What you may not know is that the law got really fascinated. I'm sure there were little seminars like this. They didn't have PowerPoint back then. Here's what was published in the Yale Law Journal about psychosurgery. Psychosurgery has startling implications for rehabilitation. Perfection of so relatively simple and inexpensive a rehabilitative technique as the prefrontal lobotomy promises to be a major contribution to the cure of criminals. And in the room, I see some snickering, which is right, because we think lobotomy, we would never do that. The law would never be stupid enough to think, oh, wait a second, let's kind of go back and well, how can law evaluate science? It's another core problem. We're talking interdisciplinary work. We're trained as lawyers. We're not trained as scientists, so we're going to look to you and your mechanisms for assessing science. So Dr. Moniz might say, well, I don't know, I've got this thing called a Nobel Prize, maybe that's a credential I need, right? So how do we in law evaluate new technologies, especially when they could be used? And thankfully, this was not widely used and maybe not used at all, but could have been. All right, so what about the present? Just kind of keeping that past in mind. Well, there's a lot to say. I won't say it all, but I'll say a few things. I'd like to start my little journey here about 12 years ago when I was doing a postdoc fellowship. I did my graduate work here. By the way, I came in I had never once thought in my life about the intersection of neuroscience and law. Not once. I credit Professor Steve Pinker here for putting me down this track. But after I was doing my fellowship, I got involved in a casebook called our Law and Neuroscience Casebook. And we tried to get a publisher, to present it. We went out for the reviews. And here's what one of the reviewers said. I have one concern. The topics are so hypothetical and conjectural that most students will find the course impractical. Very few students can afford to take this course, right? Most professors are left wondering, what, if anything, neuroscience can ever say that's truly useful to law? I see little present market for this course book. I will give the reviewers some credit. They acknowledge that there may be worthwhile to invest now, and of course that might emerge. Well, I'm happy to say that they did accept our article, that review notwithstanding, and in the 6 years since original publication, the field has continued to grow. The new edition last year has basically half the book is new. Cases that hadn't been decided, science that hadn't been published, commentary at this intersection that hadn't been developed. It's a really new emerging field. Another theme here. And all the data trends are like pointing up. So there are more, this is the upper right-hand corner. So you can, maybe I'll use the pointer on those folks in Zoom. There are more cases. There's more cases on the right, more articles being published, more public policies. The piece we did on neurolegislation citing brain science. If you're interested in more, you can go to this page. I'll put the slides up where we track cled.medium.com. We track recent cases. Now, why is there all this interest in law and neuroscience? Here's our trite yet true answer. A lot in law hinges on how brains work. We don't think about it in the law that way, but they're brain stories. What are jurors thinking? What are judges thinking? What was the defendant thinking? How much pain are you really in? Are you competent to stand trial? So on, so forth. And increasingly, brain science is something to offer those questions. I'm going to talk about just a couple of key examples with limited time. So here's one that if you work in the criminal justice system, you encounter addiction, substance use disorder. You just do. You probably do it every day. And there are new ways in which neuroscience is changing the way that we deal with mental health challenges. There are important ways I won't talk about here with new treatment programs, new medical assisted treatment, and so forth. I want to talk about here one of the big questions that when you hear law and neuroscience, you think, what about that free will thing? Okay, let's talk about it briefly. Philosophers love to ask, and I've been in many rooms where we spend hours thinking, do we have free will? If we didn't, well, I can tell you that the big question of do we have free will has had and probably will have no impact on the practical application of law. But versions of that question, does someone or does some group of someone's, is their decision-making compromised such that we might want to treat them differently? And there is a lot happening. So this is a picture, I guess I've hijacked it from the New York Times, of a beautiful image where the question is addiction a hijacked brain? Well, they said one thing that matters, we're just becoming better for understanding. That, by the way, I shouldn't overlook it. I should just mention that one of the ways that neuroscience helps law, and probably I hope helps all of us, is we just have a better understanding of why someone may do the thing we do. The example I think of is, if you have a relative who has a really strong addiction, you're still not going to maybe entrust your children to this person to watch over the weekend, but you're more understanding when at Thanksgiving they go on to this thing that they always do, right? So there's some understanding important. Treatment and sentencing, it really matters a lot. I want to talk about doctrinal change, like changing the core of the law. And I want to talk about it with a case that I see Dr. Stephanie Vashnik here in the audience. For those on the Zoom, ran a great program on this, Center for Law, Brain and Behavior. This is a picture of a defendant, Julie Eldred. And her case boiled down to this. She was going on probation after stealing some money to feed an addiction. And one of probably the first requirement for almost all probation related substance use disorder is stay drug free. Right? Well, she relapses. And she argues, and this goes up to the Massachusetts Supreme Judicial Court, that that is an unconstitutional requirement because I don't have the power to choose not to relapse. It is a medical model of addiction. It's a brain disease that you couldn't say to me, your probation requirement is you don't get cancer. Right? It's not my choice. Now, this particular case, we have more time to talk about it. The argument was rejected for various procedural and substantive reasons, but these arguments are bubbling up. And they certainly bubble up anytime there's a sentencing discussion and the prosecution is asked by the defense or the judge considers reducing the sentence again because of maybe a lack of ability control. So you may ask yourself, here's another big question. If you're on a jury and you hear about some of this brain evidence, would it matter? Right? Does it really persuade? And there's been a lot of consideration around whether and how brain imaging in particular may matter. Is there something special about brain imaging? And I can tell you that we don't know systematically. The studies are sort of mixed. I've done some of them, but I can give you illustrative cases. And this is one where a defendant named Grady Nelson was convicted and it was clear he was guilty of multiple horrible crimes. Stabbed his wife 60 times, slashed her throat, sexually assaulted and seriously hurt his stepchildren. He had multiple prior convictions, including raping a 7-year-old girl. So prosecutors, it's in Florida, 2010, they seized the death penalty. And again, guilt, there's no question is guilt. And the only options, his attorney, Terry Lenman, who I've heard speak and talk with, knew from the beginning that this was a case that was going to the sentencing phase. And this was all about whether or not Mr. Nelson gets life without the possibility of parole of the death penalty. And Terry Lenman went to a scientist, an expert, to try and get QEEG, right, he did get QEEG brain map evidence. And Terry Lenman argued to the juror, these are the lawyer's words, not the experts, my client has a broken brain. It doesn't excuse his actions, but it explains them. Well, that jury came back 50-50, 6-6, which in Florida at that time meant that he was not going to receive the death penalty. What's interesting about the case, and the reason I'm giving it to you, is that jurors don't have to talk to anyone after they resolve the case, but they are allowed to talk to the media, and 3 of them talked to a reporter from the Miami Herald. Here's what they said. Juror Dolores Cannon, hospital secretary. When the brain evidence came in, the facts about the QEEG, some of us changed our mind. Juror John Howard, airport police service worker. That QEEG evidence turned my decision all the way around. The technology really swayed me. After seeing the brain scans, I was convinced this guy had some sort of brain problem. Juror Leon Benbow, a retired mailman. All that scientific testimony, that was a waste of taxpayer money. That's phony. There's nothing wrong with that guy's brain. Now, I happen to like juror Leon Benbow, at least in terms of the evaluation of scientific evidence. I'm on record saying that, so I should say it here. But this is a clear case where, so long as you take them at their word, I don't see why we wouldn't. There is someone who would have lost his life, but for brain imaging evidence. One of the questions we ask in the neuroethics course, is this an ethical decision? Was this the right decision? Because I think that imaging is suspect, but could bad science lead to good legal outcomes? And what about the slippery slope if you go down that road? Whether it was good or bad, what is clear is that the next day, Attorney Lenman, or maybe that day, issued a big press release touting the victory in the case and the expert used, and this information circulates around. We're seeing more and more of this type of thing. All right, we've got some philosophers, I think, in the group. Let me talk about the mind-body problem and mind-brain dualism for a second. In this case, in which, this is called in Bloomfield Hills, Michigan, plaintiff, Mr. Allen, is driving this train So we want to look at the train conductor. And the train conductor, unfortunately, hits a school bus. The school bus was clearly negligent. For whatever reasons, it swerved out. You know, the traffic signal goes down, ding, 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 ding. And this school bus, for inexplicable reasons, tries to run it, gets hit by the train. Mr. Allen's conducting the train, tries to stop, but hits. Now, when a train, this is not the actual picture, but it illustrates it. When a train hits a bus, the train wins. So Mr. Allen, this is key for the legal case, you know, he's shocked, he's traumatized, but he's not, I'm gonna put in quotes, physically hurt, right? Thankfully, there were no kids on the bus. The bus driver does suffer significant injuries. Our case is against the city of Bloomfield Hills, or Mr. Allen's case was. And the city of Bloomfield Hills said, well, you know, there's a thing called government immunity. And the way the Michigan statute reads, and most statutes reads, is that the government agency, the city of Bloomfield Hills, the school district, will be liable for bodily injuries, but not mental injuries. So is Mr. Allen's PTSD, and he is diagnosed with PTSD, is his PTSD a physical injury or a mental injury? It turns out that in the world of law and insurance coverage, this has major, major consequences. It's one of the reasons we have tried to have mental health parity in insurance coverage and haven't really achieved it. Of course, the stigma is very different as well. Just an example. Next time, we'll talk about all these other things before I move on, because I've got cases and slides for all of them. Lie detection, which is the holy grail of law and neuroscience. If you can solve it, let's talk, but it's hard, maybe impossible. Memory in the law, there have been significant changes in eyewitness memory laws due to emerging science, behavioral genetics. I've just focused on the US case. Each legal system is different, and we've got a lot of international collaborators. Everything from baby brains to aging brains, educational neuroscience. There's an entire program here in the Graduate School of Education for an educational neuroscience, neuromarketing, pain in the law, emotions in law, juror and judicial decision making, all sorts of sentencing and punishment. Our colleague Bob Trug is, you know, a leader on brain death. I've run a multi-year program on sports concussions and brain injury and more. But we don't have time, so I need to cut to the chase, which is this. It's new, our field, but it's not brand new. In 2007, before I kind of became involved, I was just kind of learning about it, it graced the cover of the New York Times. And although 2021 and now in 2022, there are instances of change, I've given you some. Neuroscience certainly has not fundamentally changed the law. Most lawyers pay no attention to neuroscience. Most judges don't see neuroscience. It's not yet a thing. I mean, it is here, but it's not out there. Why? So I think it's this. I don't think that there's not a future. I think that the future requires more individualized, precise, and actionable knowledge. And the same could probably be said for a lot of areas of medicine. Right? You don't stop the genetics research because, well, it's been 2 years and you haven't solved. You know, no. Right? You invest more. So we need to know more specifically about how justice-involved individuals process information. I'm using this word sort of deliberately, and how inputs that can be environmental, social, medical, can productively change that information processing and subsequent behavior. And I'll give you an example of a place where this is starting to happen, but it's still quite controversial, and that's the area of juvenile and emerging adult justice. So this is a great slide, a great image that came from Illinois, but it references some major Supreme Court and additional cases. This is again in Illinois, related to the sentencing of juveniles. So up until 2005, if you were 17, you could be put to death for a crime that you committed. And in 2005, in the case in Roper v. Simmons, the court ruled that the death penalty was unconstitutional, was cruel and unusual in the 8th Amendment for those below the age of 18. Subsequent cases, Graham and then Miller, then Montgomery made it retroactive, said that, well, not only can you not sentence juvenile to death, you can't sentence them to life without the possibility of parole, without there's sort of a caveat, sort of meaningful so-called Miller hearing. In other words, the court has taken a real turn to adding new protections for juveniles. What's notable for us in this talk is that in those cases, there has been significant both amicus briefs mentioned by the court, significant amicus briefs, and then some mention of those briefs in the court of developmental science. Right? It's a place where you can point to major changes in the law, due in part to adolescent brain science. Notably, that was group average science. Right? So you take an entire class and you say, we've got a lot of evidence about the way brains develop and the way, in particular, the circuits related to decision-making, impulse control, and like develop, and we'll make a bright line rule. There are now some ways in which this is playing out, and I'll just give you one example from Minnesota. I do bounce back between the two states. So my colleagues worked on this case, and it happened in 2020 December that our governor commuted the sentence of Mayan Burrell And I just want to note that in commuting the sentence, Governor Walz cited science. You cannot turn a blind eye to the developments in science and law as we look at this case. And there are many instances like this. But there's also a challenge. And here is the original case. This is the victim, Shirley Crook. There's the Christopher Simmons. And in that case, in the dissent, Justice O'Connor noted this group to individual inference challenge. She wrote, "It is beyond cavil that juveniles as a class are generally less mature and less responsible, so forth. But at most," said Justice O'Connor, "the court's argument suggests that the average 17-year-old murderer is not as culpable. But what about an individual? Pick a particular, this isn't just any old 17-year-old. This is someone, and the facts are really gruesome, who took Mrs. Crook out of her house, duct taped her, and threw her over to drown in the Merrimack River in Missouri." And Justice O'Connor said, wait a second, what about an especially depraved juvenile offender? May they be just as culpable as many adult offenders? And it turns out that if you look at the plots of data on any of those by age, you get outliers, right? You get some who are 35 who have functioning as lower, and you get some 17. And this was the argument. And this has come up again. So this was a case up in more recently in Illinois. I'll move through it and just point out this, that in rejecting an argument, this was again sort of juvenile emerging adult science, the Supreme Court in Illinois said there's failure to apply that science to the specific facts and circumstances, whether the science concerning juvenile maturity and brain development applies equally to young adults or to petitioner specific, right? Courts really want individualized data. Again, a lot more could be said, but we're almost out of time, so I need to move to the future. All right, the future of law and neuroscience is yet to be written, but I think the following things will be involved. First of all, we're not just going to have brain imaging. A lot of neuroscience, and I understand why, has been, well, that must be brain imaging the law. Well, brain imaging matters, but just as for many medical purposes, we're moving into computational methods, digital phenotyping, smartphone, wearables, it's going to happen as well. We can get insights about the mind and the brain from other methods, and colleagues, many of them and all around this campus. We've been looking at that and at the associated ethical and legal dilemmas that arise as you gather intimate data. You know, there are issues around racial, gender, socioeconomic equity, justice, and bias. Moreover, if you want to scare a human neuroscience researcher, ask them this question: where do you recruit your participants from? Have you ever done any community engaged research, or do you just go to your, you know, whatever the local option is? And the answer is, unfortunately, because it's not the way it's been done, it's been very research centered, and those samples are anything but representative. So we're doing work, and I'll mention at the end, with different groups around. One is More Than Words. They also have a great bookstore, so plug for their bookstore. And plug with Dr. Pinchuk, Robert Pinchuk. This is a Zoom call from work that he led with them a couple summers ago. We're re-engaging youth, and there are many other groups around to think about more community-centered and engaged work on these issues, right? Who are the justice-involved individuals who are actually affected? There's another big wave coming around biomarkers, and I can tell you right now, the law is uncertain about how it's going to deal with the worlds that you are creating, right? So whether it's Alzheimer's or something else, or autism spectrum disorder, the law is really confused. And I'll just give the really quick reason why. Take undue influence. This is aging brains. Undue influence is the idea that someone's unduly influencing you. I'll give the example. So we already have done this all the time. Anyone who works in medicine and law, take a clinical diagnosis and try and give it a legal connection, legal translation. And that's tough because clinical diagnosis isn't easy. You know that, the clinicians. And then legal categories aren't well defined. So you put those two together, you've got confusion. Here's the undue influence, but just look at the language. This is the legal kind of definition. This is one summary. Undue influence, imagine grandma or grandpa, and they've changed their will, and you think the reason they changed their will is not because they really wanted to, but because this person, this wonderful, nice person who they just met, suddenly is having them change their will, okay? When a fiduciary or confidential relationship exists, when one person substitutes his or her, their own will for that of the influenced person's will, right? Substitute your will, what does that mean? That's the language we use in law. So we've been asking a brain question. Did the influencer modify the victim's brain such that those brain circuits that constitute the will, whatever those are, for processing information as the influencer wished? And who knows, and I'll just add this, here's our confusion, because now you're going to have brain data and digital phenotyping data this as well. And just because a brain looks normal doesn't mean it's not functioning well. And a brain that may have all sorts of tau abnormalities may not necessarily lead to great confusion, which we could talk about more. There's going to be more portable brain imaging. I'll lead a lot of work on this. Have Sean Dione drive to your house with his MR in his van. We actually put in a grant to get a van like this too. We haven't gotten it yet, but I could have that. And we'll see scenes like this. This is another grant that I lead. That we can picture this happening in the same way that you draw blood. These scanners will soon be able to, actually almost already able to collect from it. All right, so what do we do with all that? Well, the idea, and I want to give a shout out to Dr. Kinshirf, to Stephanie Judy Ederson on Bruce Price's Center for Law, Brain, and Behavior. The idea there is better decisions in line with science, lead to better outcomes in line with justice, but with like all the caveats that I just mentioned. It's not an easy arrow to draw, but there is impact being felt. Judges come to this campus each year, I guess now post-Zoom and virtually, to learn these things and to work in teams. And one judge, Esther Salas, has talked about the way that learning about neuroscience is better understanding, especially about trauma. We can talk about trauma, and has changed the way that she works. All right, so get involved. That's the last message here. Here are ways that you can get involved. And all of these are new. So here is new just within the last, I don't know, 6 months. So shout out to Rachel Conrad, Rachel Asher, Matt Baum, and the crew at the Harvard Neuroethics Hub. We are currently hiring, there are fellowships available, harvardneuroethicshub.org. This is really, as Josh was saying, an opportunity for our Harvard campus to come together around these neuroscience and society issues. My lab is brand new. We're just getting finally started. And so we're hiring, and also opens other type of engagement like independent studies, theses, et cetera. We will monitor any of the kind of stuff that I mentioned before. I'm running, as of a month ago, a few weeks ago, we just got funded to run a career network in neuroscience and society. I'm really excited about this because one of, again, the problems of these fields is that they're small and that the fields themselves are not representative. Because why? No one's ever heard of neuroscience and law outside of the 30 people in this room, the 60 on Zoom. Nobody else has heard of it. And it's only once you hear of it and get excited about it that the field grows. So we're going to be doing, if you're interested in like networking and really being in the trenches, and you like neuroscience and society road trips, we're going to do that with the Career Network. And then this is the last one. And this is just announced this morning publicly. So Gabe and I didn't know if we could say this or not, but it's public now, so we can say it. We're really excited. Josh is involved, and Perzad, and both of the centers sponsoring this in a planning grant for a Center for Neuroscience and Society, sponsored by the Dana Foundation. We've got 5 months to pull together a proposal for what we think a Center for Neuroscience and Society should look like to address, some of the issues Gabe mentioned, or I mentioned, or others. We have, there's our messy diagram of all the different groups that we want to get involved in more. There's so many on this campus and in our ecosystem, and so many community members. We just think it's going to be really, really exciting. And that's a great way for you to get involved. So get involved, stay tuned. And I guess, Gabe, we should turn to questions. So.
We're a little late, but we did have a few.
Yeah, we have until 4:45.
Oh, okay, great. So I copied a few questions from the chat before we started, and maybe I'll start with them and then I will look at the chat. But first, let's see if there are people in the room who have questions. You get precedence because you showed up.
What are some ways that you are worried about how neuroscience will be used in the law? So besides just having either bad brain imaging or imaging that's misrepresented by physicians or something else, like what do you worry about, I guess?
Gabe, do you want to start? I've got a laundry list. Do you want to start? Did you hear the question?
No, take it away. Take it away.
Okay, yeah. So the question, if you didn't hear it on Zoom, was what are you worried about with the introduction of neuroscience and law? And I'm worried about inappropriate and premature use. And so I didn't have time to talk about it, but I will. There have already been more than one case where fMRI-based lie detection evidence has been proffered. And were it not for some experts, neuroscientists, and biostatisticians testifying in 2010 in a little court, well, not little, but in a courthouse in Tennessee, I think it's likely that we would have the introduction of a completely ridiculous purported brain-based lie detection evidence in the courtroom, which could have really set things back. There's not a great history of guardrails for forensic science in the criminal law. We get a lot of bad science in. And the way the law works is on precedent. So we do now what we did last year. Why did we do it last year? Because we did it the year before. So that's one of the things that really, really worries me is bad science getting in and sort of being sexy and exciting. And I guess the just addition is I'm also concerned about the temptation to reach good, or what one might think is a good legal outcome, and taking shortcuts on the science because it seems to help in your case. Because I think downstream it could be really problematic.
Could I just follow up on that before? In terms of genetic evidence, my understanding is that that has been allowed in court a few times. Where does that stand?
Yeah, so the question about behavioral genetic evidence, it has been allowed in court, and that evidence spans from just evidence about talking about my parents did this, or to and Gabe, actually, you should talk about this too, because genetics is your value. But I'll just say it's been mainly proffered because it's hard to muster the resources to do much outside of these contexts in death penalty cases or where there's a really heavy sentence. And it hasn't, I think the conclusion is it hasn't really moved the needle a lot because there's so much other evidence that courts can use to evaluate, that they can use to evaluate and make their legal decision. But it is showing up and more than before. And I was just talking with actually Steve Hyman about like trying to think more productively about this as the ability to get that evidence is suddenly becoming a lot easier.
Other questions? Yes, in the back.
Okay. Yes. So my question's on if you could go just a bit more in depth into the general possible frameworks towards dealing with probabilistic biomarkers, as you mentioned earlier. Yeah.
Gabe, do you want to talk about biomarkers at all? And
could you repeat the question? My bad. I was gonna so I mean related to biomarkers. So I think with the growth of all these genome-wide association studies for psychiatric disorders, one of the things that comes with that is a lot of phenotyping, endophenotyping as well, but a lot of behavioral phenotyping of different kinds. And so as you collect that data together with the genetic data, that's how we end up with studies on genome, like polygenic scores for educational attainment, etc. And in terms of the law, there's very little. So, for example, I've talked to many of the colleagues in the psychiatric genetics community that have worked really hard to try to, develop these large samples so that you can actually say something meaningful about what may be the architecture, the genomic architecture of some of these psychiatric disorders. There's not much that they can do to stop some of the potential misuses of this information, and that's in part a legal problem. And as we start seeing the growth of the data banks being made publicly available, which they are often publicly available, then we may start seeing some applications also in the courts about some of the different phenotypes, like, well, this kid, there was a scale that showed that a number of kids had certain levels of aggression, and that correlates with this polygenic score of whatever, and people joke about now everyone's developing a polygenic score for something. So as we move forward in the genomics world with increasing capacity to genotype and phenotype, I think we're gonna see a lot of potential applications and misapplications in the legal system.
Yeah, I would just add, there's something called GINA, the Genetic Information Non-Discrimination Act, which basically says, look, insurers, a whole bunch of others can't take that genetic information and discriminate against you. So we've been talking about, we haven't talked about this, about BINA, the Brain and Behavior Information Non-Discrimination Act, because that's actually the whole purpose of a lot of this data collection is, of course, to discriminate. Now it's sold as to personalize. You'd love to personalize your choices by giving you the higher insurance premium. So, right, I think it's a real problem. I agree with Gabe.
One more here, and then let me read a few from the chat.
Yeah, I guess kind of building off of that for the sort of probabilistic biomarkers, but also just sort of thinking about the problem of individualization. Like the vast majority of neuroscience information is probabilistic in some sort, like especially when it comes to behavior. There's basically nothing that's like 100%. And so like, how does that sort of like varying degrees of evidence and like probabilistic connection kind of apply to any individual case and like how that would be viewed in the courtroom?
This is a great question. So I'll just repeat it. You didn't hear on Zoom that the point is that the neuroscientific evidence, I mean, all scientific evidence or most is probabilistic in nature. That's why you have, significant bands, right? And so one of the big challenges is that some, though not all of law, is binary. So we do not bring back a 77% likelihood of guilt, right? There's no juror foreman or person's ever come back with that. Moreover, no one's ever come back and said, you're 77% likely to receive your disability benefits, right? You either do or you don't in a lot of contexts. And so I think the thresholds really matter. Another example would be, do you qualify for the special education benefits? Does your child qualify? These thresholding, rules and standards is like what we teach 1L, or you've seen it in other contexts. We use rules because they're easy to administer and we need them. I think the concern that I have is that sometimes the probabilistic biomarkers are developed without recognizing that there are all these threshold rule implications. Because if you're just doing science, the idea is, well, it's okay to have, and of course it is, right? It's still going to be probabilistic. It's going to allow the physician to make a decision about with the patient about whether to use drug regimen. Right? Okay, that's fine. But outside that context, there's a lot of these social and legal implications. The other thing I say is that no one outside of the science community, and maybe within the science community, I don't know, understands probabilities. So I work on aging brains. There's effort by the the National Institute of Aging and the Alzheimer's Association to create an Alzheimer's spectrum, which makes all the scientific sense in the world. And you could look at someone who's on the spectrum early based on their biomarkers in blood, but they have no symptoms. If I told you right now, hey, I'm your Uber driver, just so you know, I'm on the Alzheimer's spectrum, it's something like, well, wait a second, right? No one's going to, because socially, we don't know how to handle that. And the law doesn't know how to handle that. So I don't know how we're going to do it. I mean, the answer is to do like what Josh does a lot, putting people in the same room, national academy, so forth. Really tough question.
So let me, there were a bunch of questions actually on a topic you covered a lot, which is about whether people depending on a brain disorder or mental illness, would have culpability altered. So I won't ask that because you kind of covered it, but here are a few that you didn't cover. So one is, in the future, can you imagine that punishments might be geared towards specific diagnoses? For example, rehabilitation versus quarantine versus jail time, depending on brain data, depending on diagnostics.
Yeah, so we already have some of this. There's so-called treatment and specialty courts that have been around a couple decades. And they're ways that you bypass the standard court and you qualify or you're put into those courts. It's not usually brain data, or rarely if ever brain data, but it's information about your behavior. So there are veterans courts. So if you've experienced certain trauma and combat veteran, you can go there. There are substance use treatment courts. So I think we're already probably going that way. How personalized it will get, we'll see. But I think things are trending that way in some respects.
So here's another one that's more practical. Are there any existing dual degree programs?
Oh, yes. So, it's a great question. I just on the phone yesterday, some about this. So there are, the University of Minnesota has a small one, Vanderbilt has a small one, and the University of Wisconsin-Madison has a slightly larger one. But what I would say to anyone thinking about that is, well, one, email us and talk with us, because you can also craft your own program, and many folks have. And figuring out, this was the conversation yesterday, like how exactly do you want to enter the field of neuroscience and society? And lots of folks enter with just one degree, and that's awesome because they're a great neurobiologist or they're a great lawyer, but they become familiar with another field. So, and there's also a YouTube video, if you Google it, that I did called A Student's Guide to Law and Neuroscience. We're going to update it, but it's got some updates. So good question, dual degrees. Yeah.
So I guess given the time, we should probably stop now. Is that right, Farazad? Or
Yeah.
And thank everybody. Write to Francis or Gabe if you haven't had your question answered.
Thanks, Gabe.
Out there in the
Thank you
world.
so much.
And if you're here, I think there's going to be a reception. So
Cool.
Thank you.
Thanks, guys.